Serial number 2 was called out. प्रभाकर सिंह। हाँ? अच्छा, तो ये प्रभाकर सिंह के नाम से केस था। हमने कल न्यूज पढ़ा था कि उनके फादर का डेथ हो गया, इसलिए पास ओवर कर दिया है। बट इफ यू आर अपीयरिंग वी विल हियर यू।
सीरियल नंबर 2 में हम हुजूर मेंशन किए थे, मेरा भी नाम है हुजूर।
ऑल राइट, so we are inclined to hear you because you did not come up to argue, therefore we adjourned the matter. चलिए बहस करिए। आप Mr. Court Master, please find out that when you call out the names or the number of the case, the counsels should hear that.
Okay.
He was sitting here and
he has just come, just entered into courtroom.
आई बस करिए
जी।
प्रभाकर सिंह लड़की को लगता है एनओसी दे दिया।
That's all right. So now Prabhakar Singh is not the advocate on record, therefore we will hear him.
Yes.
You please take your seat. We will call upon you. Yes.
Yes. This appeal is directed, the order dated 10/5/99 passed by the Honorable Court, my lord. In the writ petition has been dismissed for ground of the decision, my lord.
Yes. Continue. Continue your argument.
Yes,
We are
sir.
hearing you.
The, my lord, in this case, my lord, the initial the landholder by the Bajnath Singh and the sealing proceeding has been done against the Bajnath estate versus Bajnath Singh, my lord. And the Lecture 4, my lord, the order passed by the in the writ petition, my lord, order passed by the additional cutter in which the 2 unit has been given to the landholder, my lord. One wife of the Bajnath Singh and wife of the Shiv Shankar Singh, lord. In this, my lord, the main landholder is the Kalka Singh, my lord. Kalka Singh is 2 sons, my lord, Bajnath Singh and Shiv Shankar Singh, lord. And during the land sealing, my lord, the page number 18, my lord, in the writ petition, my lord, 11/8/2088, the lender additional given the 2 share. May I permit to read, my lord?
Yes.
पेज 18 रिट पटिशन, मिलो। बुधारी की विधान व्यवस्था को सुना। इनका दावा है कि इनके परिवार में वर्ग 4 की 63 एकड़ जमीन है, जिसमें परिवार के कुल 5 इकाई देह है। 2 इकाई या तो बैजनाथ सिराराम प्यारिया कुंवर को दिया जा चुका है और राजेंद्र सिंह, गोदावरी देवी पुत्र स्वर्गीय शिवशंकर सिंह, चंद्रभान सिंह, मृत्युंजय सिंह और रामेश्वर सिंह को व्यवस्था की इकाई मिलनी चाहिए था, जो नहीं दिया गया। जहाँ तक भूमि वर्गीकरण का प्रश्न है कि बुधारी की ओर से कहा गया है कि इनकी भूमि की सिंचाई किसी प्रकार से मोटर पंप से होती है, जो वर्ग 4 में आएगी, क्योंकि इसके सिंचाई का कोई सुनिश्चित साधन नहीं है। अतः सरकारी अधिवक्ता का तर्क है कि अभिलेख एवं प्रतिवेदन से स्पष्ट होता है। My senior is arguing.
Sorry for your lordship convenience.
No, that's all right. You can take over.
Yeah.
You can take over. You can take over.
Oblige. Annexure 4, the order dated 11th of August 1988.
Yes.
पारिवारिक के विद्वान अधिवक्ता को सुना। इनका दावा है कि इनके परिवार के वर्ग 4 की 63.2 एकड़ जमीन है, जिसमें उनके परिवार के कुछ 5 इकाई देह है। 2 इकाई यथा बैजनाथ सिंह और राम प्यारी कुंवर को दिया जा चुका है और राजेंद्र सिंह, गोदावरी देवी पुत्री स्वर्गीय शिवशंकर सिंह।
When the collector modified that order dated 11/8/1988, he gave 1 major unit and 3 additional units.
So 1 major unit and
3
1/10
That's
minor
all right.
unit.
So who was granted 1 major unit?
Rajinder Singh.
And was there any decision?
Rajinder Singh is the son of
Just a minute. Mr. Devan
Bajnath
Singh,
Singh.
please answer the question. Now, was there any decision with respect to Chandrabhan Singh?
Chandrbhan Singh is brother of Rajinder.
Was there any decision by the collector against the order of the additional collector with respect to the right of Chandrabhan Singh to get a unit? No.
No.
Now, therefore, you for the first time placed reliance on some retirement letter of Chandrabhan Singh saying
Yeah.
that he could not have been a minor,
Yeah, yeah.
and therefore he should be given.
Yeah,
that's
right.
what that's
Yes.
what the single
Yes,
judge
yes,
has said.
yes, that is
now,
very
thereafter,
Ji.
the matter you came before the court straight away after the order of the collector.
कलेक्टर के बाद चले
First
गए
time-
बोर्ड ऑफ रेवेन्यू
No. First time, did you come before this court before the revision petition or after the revision petition?
पार्डन
When the collector passed an order modifying the order of the additional
Yeah.
collector,
Yeah.
did you go before the revision before the board of revenue or you came here?
No, board of revenue.
You went before the board
Yes,
of revenue.
yes.
What did the board of revenue do?
No, nothing. He has nothing done, my lord. He has dismissed the application, my lord. Thereafter, the writ petition in 2006.
1993. What
Yeah.
happened? What did the board decide in 1993? Because you filed a writ petition in 2006.
Six.
Is that
Of
correct?
Yeah, that's right.
Now, 1993, what did the additional member decide?
That is because, my lord, the case was pending before the board of revenue, my lord.
That's right.
Both the appellants were dead, my lord.
That's right.
And the appellants were not informed by his lawyers, my lord. This is the plea, my lord. That is the facts, my lord. They were not informed कि आपका केस ऐसे ऐसे हो गया है. And in 2005,
Ultimately, did the board of revenue dismiss the petition for non-prosecution? Now, what was the order of the additional member board of revenue? The question is, Mr. Nay, perhaps you are not understanding. There are certain gaps in between the dates on which you are prepared,
Yeah.
Mr. Singh. Now, 67 acres was found, out of which 27 acres was found to be class 2 land. And therefore necessary necessary notification under 15(1) was directed to be published. Is that factually correct?
yeah,
Then thereafter you appealed before the collector, and collector made minor modification
Yeah.
of granting 1 major unit and 3 additional
Yes,
units.
yes.
You challenged that order before the board of revenue.
All right.
We have no idea about the order passed by board of revenue. The single judge does not discuss it. You are not addressing it.
yeah.
Therefore, you need to tell us what was the order.
Your lordship, we kindly see Annexure 1. Annexure 1 is the board of revenue order, my lord.
What does it say?
Yes, oblige.
You want the court to decide and revert the matter to the learned single judge because that was not seen. Let us see where has the learned single judge erred.
Your lordship, may kindly see page 10 of my appeal, my lord.
Tell us what is it.
Read में annexure 1. In annexure 1, Mr. Mahesh Prasad number 2 was appearing for the petition. Name is there.
What is the order of the board
Order is the
against which you came running to this court in 2006, Mr. I'm asking very simple questions on facts
Yeah,
for us to justify
yes.
reviewing this order in appeal against the learned single judge who says that your case is hopelessly time barred.
The board ordered, my lord, the petition was dismissed, observing
On
that
what
the
ground?
collector order is the right order.
Hmm.
This is the observation made by the Board of Revenue, my lord. Last page of the order, it is stated, my lord. Ultimately, the
So
case was dismissed.
thereafter the matter was referred to the tribunal
Yeah.
by this court.
Tribunal by this court, my lord.
By this court.
Ji.
Now, we are not finding any justification to interfere with the order for the reason that there has been an unnecessary delay for which there is no explanation, and the parcha holder has also been an intervener.
No. The IN number 2, my lord, in which I have been stated, all the lines are in our position.
The court perhaps has gone to the extent of saying that when this order was passed and parcha was issued, why was it not given? Yes, mister?
Yes.
Till date, we have not given possession of the landlord.
Till date you have not been given possession of the land. Why?
Because कहा जाता है हुजूर कि before the court मामला पेंडिंग है, सीओ साहब के द्वारा, इसीलिए हम नहीं कर सकते.
Likhiye. Heard Mr. Devendra Kumar Singh, learned advocate for the appellants, Mr.
Arun
We
Kumar
are not inclined, we are dismissing this appeal.
Arun Kumar Bhagat, AC to AG
Mr.
12.
Arun Kumar Bhagat for the state and Mr.
Vishwajit Pandey. Vishwajit Pandey.
Mr. Vishwajit Pandey for private respondent number 6, who is said to be the parcha holder. A land sealing case was initiated in the year 1973-74, bracket mein LC case number 43 of 1973-74, against the landowner under the Bihar Land Reforms, bracket fixation of ceiling area and acquisition of surplus land act 1961. Stop. In the aforesaid proceedings, 27.02 acres of class 2 land held by the landlord was found to be surplus by the additional collector. Stop. The collector in sealing appeal number 5 of 1989 found that wrongly one major unit and 3 additional units were not given to the landholders, and thus the order of the additional collector referred to above was modified by giving additional unit, additional measure and other units to the landholders.
And
This order of the collector was challenged before the Board of Revenue in revision, namely sealing revision case number 226 of 1989, which was not interfered with, and the board dismissed the aforesaid revision petition on 15/10/1993. The learned single judge, while deciding the issue, has found that nearly 13 years after the passing of the order in revision, a writ petition was filed by CWJC number 7407 of 2006, wherein a direction was given for transferring of the records of the case to the Bihar Land Tribunal, which had already been set up, and the act in question formed part of the schedule of the rules. During the pendency of the aforesaid petition before the during the pendency of the aforesaid proceeding before the tribunal, there was a major amendment in Bihar Sealing Act, by which section 45B was repealed and section 45D was inserted, through which all matters pertaining to such operations were directed to abate. As mandatorily required, the tribunal disposed of the matter as having abated. Next, Mr. Singh, learned advocate for the appellant, submits that this led to the revival of the case of the appellants, who again approached this court by CWJC number 20355 of 2016. Of 2016. The learned single judge, on the sole issue of the Board of Revenue in the first instance not having entertained the matter, as such revision was filed after 13 years. The learned single judge noting that after the order passed by the additional member Board of Revenue in the year 1993, the appellants had challenged such order only in the year 2006. That is after 13 long years. It was also noted by the learned single judge that the parcha holder, namely private respondent number 6, who today claims that he has yet not been handed over the land for the reason of pendency of the proceeding. क्या लिखा है? How have I begun that sentence? Reflects that the provisions under the Act are not being carried out by the authorities within the timeline fixed, and the unnecessary delay in such execution has only led to disentitlement of such parcha holders. The learned single judge was absolutely correct in finding that there was that it was not agitated before any forum with respect to allotment of parcha to private respondent number 6, which was wrongly not executed and delivered to him only for the reason of pendency of this proceeding. The learned single judge has rightly referred to various decisions of the Supreme Court to justify that any belated claim without any cogent explanation ought not to be entertained by the courts exercising writ jurisdiction. We are in agreement with the decision of the learned single judge. For practical purposes also, we find that no good purpose would be served in entertaining the aforesaid appeal, and we are also persuaded to direct that the parcha issued in favor of private respondent be made effective and the land in question be distributed to him. Since there is no merit in this appeal, we are left with no option but to dismiss the same. The appeal is dismissed.